Okay, there we go. Okay, so our presentation today is taking the oh no out of the OMA, and the kind of the impetus of this presentation. So my intent is hopefully not just to give you a boring overview of the OMA, but I'm trying to put it in the view of the questions that I get most often. So to try to kind of organize it in terms of the things that people seem to be most confused about, or that I usually get, either notifications that boards are not doing correctly, or that boards have a question about. So that's kind of how I've organized it, to hopefully make it a little bit more interesting. So here's my standard disclaimer. As you all or most of you know, I am the library law consultant. I have a library degree and a law degree, but I am not licensed to practice in Michigan, and that's actually a good thing. So I cannot represent you, also because that's not my job here at the state of Michigan. I'm here to provide information. My background is a law librarian. I spent a lot of my career teaching law students and providing legal reference assistance to faculty and staff and members of the public. So I look at myself as kind of the law librarian for librarians. So if you have, my job is to provide information and kind of hopefully help you forge a path through your legal issues. But when things really come down to a yes or no decision, or something where you need to be pointed in a particular direction, or your board needs to be told like flat out what to do, that's when you need to get your attorney involved, because that's their job. So welcome. As always, there's my contact information, and at the bottom is the link to our survey. We really appreciate it if you fill out the survey. I've had some very helpful comments. It really does help me with my presentation style, and it helps me understand the kinds of things that you like, and the kinds of ways you learn, and the kinds of topics perhaps that you'd like to hear about. So whenever I talk about statutes, and the Open Meetings Act is really completely statutorily based. Okay, some areas of law are what we call common law areas, and a common law area would be something like contracts, or liability is very common law. Those kinds of things are really rooted in case law. So the legal authority that tells you how you have to behave is all rooted in, what judges have said in case law. But Open Meetings Act is all statutory based. So that, in a way, it's easier, because it's laid out specifically by the legislature in the law. It tells you exactly how you're supposed to behave, and what is okay and what isn't. The problem with legislation is that sometimes when legislation is written, the legislators that actually wrote it may have something different in mind than the way the topic evolves. Or sometimes language is put in that's a little cagey, and sometimes it's a little fuzzy, and it's unsure of, well, did they mean this or did they mean that? And that's where the courts come in. So as statutes are litigated, and as cases come up that involve those statutes, judges rule to determine how a particular phrase of the statute means, and how it's supposed to be interpreted. So whenever I look at statutes, I always like to say, okay, so what is the purpose of this statute? What was the intent of the legislature in putting this statute out? Because that can sometimes help inform when you have to make a judgment call and how to behave. So in this instance, we know that the Open Meetings Act, which is not that dissimilar to acts all across the country. Some states call them government in the sunshine. Some states call them open meetings. They have, different labels. But essentially what all of these acts, and the one in Michigan, are meant to do is to enable citizens to have contact and participation in the meetings and the operations of government. So if you look at our country as, by the people, for the people, that this is one of the acts that makes that possible. So the Open Meetings Act makes it possible for us, the people who vote for the legislature, and who, pay to taxes. It makes it possible for us to participate in the meetings and in the discussions and in the decision making of our governments. And this goes all the way from the state legislature all the way down to your local government or your library boards. This also applies at a federal level from a different act. But for right now, we're just going to talk about Michigan. So in Michigan, it allows, our citizens to view, attend, address, and witness the work and decision-making public bodies. There are several theories that, one of the most important things about this act, along with the Freedom of Information Act, is that it enables the people to become educated in and savvy in the workings of government in order to let them assist them in making educated and informed decisions about their government and how they want things to work. So if you know that the purpose of the OMA is to provide, number one, provide access to the proceedings of government and governmental bodies, and it also provides a framework. So it provides, if you just said, okay, every member of the public gets access to public meetings, there could very quickly be a free-for-all or, so it establishes specific procedures that public bodies have to follow, not only to ensure that right of access to the public, but also to protect the public bodies and also to ensure that they can do the work that they need to do. So one of the first questions I get within the OMA is the question about public meetings. Now, if you look at the Open Meetings Act is in the Michigan compiled laws, and that's what MCL means, right? So a quick side on, legislative procedure is when the legislature passes an act. Okay, so you see public act. So when a public act is passed, the next step is it gets broken into parts and placed into what is called the codification, which is the Michigan compiled laws. So the official, quote unquote, from a legal perspective, so the information that judges and attorneys utilize when they're reading, quote unquote, the law, is the Michigan compiled laws. And the Michigan compiled laws essentially divides all of the public acts up by subject matter. So it makes it easier to locate a particular law, and it allows the laws to be kept current. So as language changes and laws are amended, the Michigan compiled laws makes it easy for the legislature to apply changes in wording to existing statutes. So if you look at it like the public meeting, the OMA has been amended about half a dozen times since the 70s when it first was put into, when the current version was first passed. So if you think of 6 different public acts, right? Or 12 different public acts, and you say, okay, you have the original act, and then on top of that, you have the First Amendment. So you got to take the language out of what changed out of that amendment, and you got to apply it to the original act. So you got to take words out, put words in, and then you get to the Third Amendment, the Second Amendment, and you got to do that again. So, when you have to do that, it gets very confusing and very difficult to read the current language of the law. And that's the value of the Michigan compiled laws. The Michigan compiled laws are also have a good index. And so you're able to quickly locate things by topic. You can also locate things by the handy number here. And you know that anytime you go to chapter 15 to 0.263, or actually it's 0.261 continuing, you're going to get to the Public Meetings Act. And then if you look at everything in 15, in chapter 15 is where you're going to find all of kind of the public office behavior stuff. So FOIA is there. The Incompatible Offices Act is there. So all of the things that kind of deal with behavior kinds of things are in 15. And then 263 are then the particular laws. So if you think about it, it's kind of like a cataloging, right? So if we we're going to spend a lot of time on 15.263 today, because this is where the bulk of the meat of the Open Meetings Act really is in this one section. So this section tells us that all deliberations of a public body constituting a quorum of its members must take place at a meeting open to the public, right? And then it gives an exception. Well, these exceptions have to do with with closed sessions. So we're going to get to that a little bit later. So all deliberations of a public body and a quorum. So when we talk about quorums, right, one of the things we always tell new board members is that once a board should establish its quorum in its bylaws, so if you are a board of 6 elected members, your quorum is going to be the majority of the members, right? So that's going to be 4. So your quorum is going to be 4 members. And so if you have 4 members together, then automatically under the law, that's a public meeting. And the reasoning behind that, now there's a couple exceptions to that we're going to get to later, but generally, if the majority of the board are together in one place, particularly if it's a place where there's the likelihood of a discussion of library business, then that's a public meeting. And so it's imperative that that if you go back to the idea that the purpose of the OMA is to permit access to decision making, that's the idea is that, okay, if you have a quorum of the board together, then there's the possibility that discussions could lead to certain decision making, and if you do that in private without the members of the public, now you're cutting the members of the public out from that right to participate in that decision making. It also says that when you have a meeting, and we're actually going to get to this in a minute, when you have a meeting with public body and members of the public come, you can't have qualifications to enter the meeting, right? You can't say, I need to see your ID, I need to make sure that you're really located in this area. You're not allowed to say, restrict members of the public or force them to give their names or identify themselves as being a part of that public body or a part of that public meeting. The other part of this section 15.263, and this is subsection 2. So if we go back to the slide before, this is subsections 3 and 4. So if we go to this one now, subsection 2, it says that all decisions of a public body must be made at a meeting open to the public. So you're going to see a lot of this is the same language kind of over and over again, right? So this says all deliberations of a public body constituting a quorum of its members must take place at a meeting open to the public, right? Well, that's not that much different than all decisions of a public body must be made at a meeting open to the public. The distinction is it's specifying a quorum, right? And this one is just being more general, that all decisions of a public body must be made. So let's talk a minute about what's a decision, right? So we talked about a quorum. So a decision is usually any deliberation or any pretty much I hate using the word decision over again, but it's where any kind of determination the public body makes on an action that affects for this purposes, the library, the operations of the library, the financing of the library, the reputation of the library, anything affecting the library, right? Because that's their job is the library. So anything affecting the library, any determination affecting the library and the operations of the library is something that's supposed to be made in an open meeting. And again, there's a couple kind of exceptions, but in general, if they're going to make decisions about purchasing, or they're going to make decisions about planning, or they're going to make decisions about how many employees, or if they're going to lay off employees, or they're going to all of that kind of stuff needs to be made in open meeting. Now, so decision making is kind of pretty widely interpreted, right? So it's not, there's not a real specific, this is a decision, but this isn't a decision. A lot of that might be if someone, say, brings suit against the board and said, oh, you made this decision not in public meeting, and it goes to court, then the court could make a determination whether that decision was something that was really covered by the OMA or not. But with lack of having that situation, which is not something any of us really want, the definition of decision is really pretty broad, right? So as a board or as a director who's guiding a board, this pretty much means that, you know, you can't have work meetings, right? There's no such thing as, you know, working group. There's no such thing as, you know, a meeting of the board that is not in open meeting. So if you have a meeting of the board in quorum, they can't do that without an open meeting if they're going to be talking about the library. And so that makes things like board retreats really pretty squishy from a legal perspective. And so I would encourage a library to work with their attorney to make sure that if they are going to have such a thing, that they are doing it properly. As I said, there are a couple exceptions we're going to get to that quorum equals a public meeting thing, but again, it's very gray, and you have to be really careful. Because as we say here at the Library of Michigan, it's not a problem till it's a problem. So you could have been having working meetings, or you could have been having retreats for years without a problem. And then all of a sudden the library is undergoing some kind of issue or is having some kind of controversy, and a member of your public latches onto that and decides to make a big deal of it. And now that's an issue. And so, you know, I get a lot of board members and even some directors, but mostly board members, who will tell me, well, our municipality does this. Well, you know, that's all well and good if your municipality does it, but, you know, they're on the same borrowed time as you, right? So just because your municipality does it doesn't mean it's right. It's kind of like your mother used to say, if everybody else would jump off a ledge, would you too, right? So things like parking lot chats, which is very hard to do. You know, if you're after a board meeting, everybody kind of gets together. And when you're on a board, you tend to, you bond, right? So you become, you know, kind of a group. And usually on a board, there might be different factions. There might be a group of people that bond and then another group of people that bond. And you have to be very careful about those kind of what may start as a social chat, which is perfectly fine. But if you start to talk, you know, oh my gosh, can you believe what Bob said in that meeting? When you start to talk about work, you know, i.e. library, that's when you get into very dangerous territory. So, you know, you can't have somebody say, hey, I have this idea. Would you vote yes if I suggested this? And then that person goes from board member to board member and says, hey, I'd like to do this. Will you vote yes? So they're essentially kind of doing round the horn decision making, it's called. So they're kind of circumventing the OMA by the time you get to an open meeting, it's a done decision, right? Where the purpose of an open meeting is to have that discussion and debate and then make the decision. Now, it doesn't mean that, you know, the OMA doesn't mean that all of individual board members can't get the information they need before a meeting, right? So you want your board members to be knowledgeable about any kind of decision or controversy that they're going to be discussing. The problem is they can't already have made a plan on how to solve it and have agreed to it and done all those negotiations in the back door, and then just go into open meeting to, you know, make it official. So that's where you can run into some problems. Why? Because the members of the public, and remember, the members of the public include the staff of the library, can include the friends of the library, can include other stakeholders in actually the library, other than, you know, just the members of the public. And all of those entities have a right to be participatory and understand that process and what went into that decision, and have a chance to stand up in public meeting and say, hey, have you considered this? Or I think that this may be a problem, or this may affect me in this way. And so it becomes very sticky when, you know, boards may think they're saving time, But that's, that's not a good process to kind of get into. And it's very easy to slip into. Even I myself have been in discussions, I present to boards a lot, and I've been, had coffee with them, and then all of a sudden you find yourself, discussing something, you have to say, oop, we have to change the subject. So it's not, I'm not saying people that do this aren't trying intentionally to do anything wrong. It just can happen, but there really has to be an awareness that this is a problem. Email and texting can also be an issue, right? Right now, it is so common for everybody to email. And, a director just sending out documents to everybody can, start a conversation on that thread, because people reply. And then before you know it, they're pretty much having a meeting via email. That's also a big problem. It doesn't mean the director shouldn't email everybody to send them information, but it means that if a conversation gets started, somebody should go in that conversation and say, you know what, we need to discuss this at open meeting. Same with texting, same with, Facebook. It doesn't matter where they're doing it. Just because they may be talking not on their library email doesn't mean that they're not violating the OMA. And as a side note, if they are using personal, their personal device or personal accounts to have these discussions on board business, then that they could be opening themselves up to FOIA, or, if there's litigation, subpoenas for their personal email and texting. So it's really better to keep board business on board devices or board accounts. Don't choose times or days for meetings when majority of the public can't attend, right? So I know boards who hold their who hold their board meetings, therefore their public meetings at 2 o'clock in the afternoon on a Wednesday. Now, that's not illegal per se, but is that in keeping with the spirit of the Open Meetings Act in terms of transparency and access? And that could depend on your community and the demographics of your community, right? So if you're in a community that's largely, older retired people or very young families, maybe that's not a bad time to do it. But if you are a community that, has a high number of, young and middle-aged people who are working during the day, then having your public meeting in the middle of the afternoon on a weekday is pretty much cutting out a large majority of people who could attend. And so you may have to look at that and say, why are we doing it that way? Right? So, there may be legitimate reasons, but again, this may be a time where board members have to sit down and say, okay, I have this public duty and I have this public office. And there was no promise in the public office that I get to do this just when it's convenient or I want to. So it may be that, there may be boards that have to sit out there and think about, gee, maybe we should really be having our public meetings at a time when the public could really attend. And again, this would be something to maybe discuss with your attorney and get their opinion. But again, it's not a problem till it's a problem, right? So, and incidentally, on a side note, if you do change your, meeting to a time that might be more attractive to a broader swath of your community. So for example, maybe you do it on a weekend at 2 o'clock in the afternoon. You may find that you can find more board members to volunteer because sometimes that's a big problem. Like right now with my job, if I was asked to be a board member, that would be problematic for me to go to a board meeting in the middle of the day on a weekday. So, that's something else to consider. Okay. So meetings can't be limited in size. This is something else that I get asked a lot, particularly right now with the pandemic and all the various restrictions and rules. Which are going to be changed starting Tuesday. So this language here in 15.2631, which we've already seen some of, all meetings of a public body must be open to the public. All persons must be permitted to attend any meeting except as otherwise provided in this act. And the otherwise provided in this act largely has to do again with closed sessions or with, you know, say public disruption. You know, so if you have a member of the public that is creating a public disturbance and is interrupting the meeting, then, you know, they can be, you know, thrown out. And that the board can have certain rules for public participation. But generally, when you just talk about the size of the meeting and walking in the door to attend the meeting, every member of the public has to be able to attend. And then section 6 says of that same 263 that a person must not be excluded from a meeting otherwise open to the public unless they're committing a breach of peace. So if they're yelling or screaming or, you know, creating a disturbance, then that's a reason to keep them out. But if you know, if you have a room that only fits 10 people and you have a 6-member board, then that only leaves 4 spaces left for members of the public. If you have a director there, that leaves 3 spaces open. That is not OMA. The idea with OMA is that you have to have enough space that everybody who you think could conceivably attend will attend. And that doesn't mean, you know, you could say, well, nobody ever comes to our meetings. Well, the law doesn't care about that. What the law cares about is that if you are discussing, maybe you're discussing something that is of a particular interest, or there's some kind of controversy, and then all of a sudden you have 25 people show up for your meeting. If you have, you know, if your room is full and you can't fit any more people in the meeting and one more person comes to attend, then you have to end the meeting. If another person comes, you cannot tell someone, I'm sorry, the room was full, you can't come in. When you have incidents of like big controversies where large groups show up, you know, unexpectedly, there are strategies that can be done to help that. And I've included some resources at the end of this presentation that explain some of that. You can always move the meeting to a larger venue. So if you have a big reading room, you can move the meeting to a reading room. If you are experiencing some kind of internal issue or some kind of issue that is generating the interest of your community, you may want to consider using a township or a city room that's larger for that particular meeting. And you can always put out an 18-hour in advance notice of a change of venue. But, you know, you can't just shrug your shoulders and say, I'm sorry, there's not enough room to come. And that includes virtual meetings too, right? So if you have, so the question we say, so if we have a board that says, okay, no one ever comes to my meeting, so I don't need to worry about if my room is too small. Well, okay, we say that's fine. But what you have to worry about is if you do have a situation where a person comes to the door and says, I want to come in, and you don't have the room. So you have to be prepared with what you're going to do when that happens. And really, unless you have a place to go to that you can move to, the answer is going to have to be, we have to end the meeting and shut down. So that's something that's really important right now with the limitations on meeting. Now, starting June 1st, as you all know, the 25-person limit was removed from the MDHHS order that we're currently under. However, you're under still your 50% occupancy and the social distancing. So on Tuesday, what's going to change is you're still under that 50% occupancy. But the way that they wrote that section is a little bit weird. So if you're a large library, it says essentially that you can have 50% occupancy or 25 people, whichever is larger. So if you're a small library, and maybe your 50% occupancy is only about, 15 or 20, you'd be able to have a public meeting in your library and have 25 people there. If you're a large library and your 50% occupancy is over 25 people, then you can have a public meeting that's as large as that 50% occupancy. But if your public meeting is the amount of your 50% occupancy, then no one else can come in your library. So Again, these are, if there's any kind of problem with those are issues to discuss, again, with your attorney to figure out the best way to manage that according to your situation. Some libraries are right now, if your location is under a local order of emergency, you could have a hybrid meeting, and we're going to talk about that in a minute. But it's important that, you keep your eye on this size issue, because it actually is pretty clear that, you can't, just because you have a small room, doesn't mean you can only have a few people. And I've even had some boards who want to hand pick the people that get to come to their meetings, and that is also not okay. So that's an important thing to note. The public has a right to speak at the meeting. So Section 5 and also Section 1 of the same MCL section addresses that, a person has to be permitted to address a meeting, but it's under rules established and recorded. So that means that the public body your board has to have a approved written list of requirements for a public meeting or rules for public comment. And that is something that is, should be in their bylaws. It should be something that has already been considered and thought about. They can be amended like anything else, but that is something definitely that you should have. And if someone does come to a meeting and public speaks, or if they just walk in the meeting, there is a right to video record and tape record. And again, the board has no say in this. There's no requirement for permission. Someone can just walk in with an iPhone and record. And there's actually, if there's been a lot of several parts of that recently, although with Zoom, that kind of records automatically. Now, again, the public body can have, there is one kind of caveat to the recording, and that's if the person recording is disrupting the meeting. So if they're setting up, tripods and they're getting in people's way and making it so that other members of the public can't see the meeting or then that, can cause, the public body to restrict their actions in some way. But just if, some Joe walks in the meeting and turns on their iPhone, there's really nothing that the board can do. And that's important to know. Everybody at a public meeting has a right to speak. The rules of public comment should contain when comment occurs, right? So do you want to have it at the beginning of the meeting? Do you want to have it at the end of the meeting? That's up to the board. Do you want to have it in the middle of the meeting? All of that is up to the board. How long comments can be. So are the comments, one efficient way that boards use to, kind of so that your meetings don't go on forever is to limit public comment to like 3 minutes. And that's perfectly fine. You can do that, and you can have someone there with a stopwatch who then tells the person, thank you. You've used up your time. Oh, we thank you for your comments, You can have rules for conduct, right? So you can have rules for behavior. You can say that, people have to be, can't yell, can't shout, can't, incite members of the public to, can't incite the other members of the public. What you can't do is say that, you can't curse, you can't berate, you can't, you have to be very careful. You can't regulate what the person says, right? So if a member of the public comes up to a board and tells them they're the worst thing they've ever seen, or that they're bastards, or that they're, some other, epithet, they can't, the board can't say you're not allowed to say that. I've had board members ask me where in situations where there is some kind of controversy and members of the public have stood up and just berated board members, or maybe it's an issue with the director and the member of the public has come up and said bad things about the director or a member of the staff. You can't regulate that, right? So freedom of speech, First Amendment, you can't regulate speech. Okay. And I would talk to your attorney even about, if you're going to have a rule on hate speech, I would definitely talk to your attorney, because even that hate speech has to be defined carefully. So you're going to want to talk to your attorney about that. I completely understand why you'd want it, but you have to be, you can't just have an individual person deciding arbitrarily on their own what constitutes hate speech and what doesn't. So just remember that you want to regulate conduct. It is not a debate session, right? So if a member of the public is challenging the board and wants answers, why did you do this? What are you doing? Didn't you consider this? Tell me, didn't you consider this? The board does not have to respond. I would suggest that your rules say this is not a debate session. I would also recommend that your rules are posted. Your public comment rules are posted in the meeting. They should also be posted on your website wherever you put your meeting notice, because obviously it's very difficult to enforce a rule that people aren't aware of, right? So one of the first rules about legal policies is that the people who you are expecting to adhere to this have to know what the rules are. And lastly, boards should model the behavior they want. So if as a board member, you really want to make sure your public comment is cordial, then you're going to want to be cordial yourself. And I'm not saying people aren't, but sometimes it's difficult if you have someone yelling at you and you have someone who is not saying nice things to you. It's human nature to want to lash out. You do not want to do that. You want to take the high road and err on the side of discretion. So again, model the behavior that you want to see from your public. Okay, let's talk about notice. This is, we're not going to spend huge amounts of time on this because this is fairly clearly outlined in the statute. I'm just going to mention a couple things. So 10 days after the first meeting of the board in the calendar year, you have to make a schedule of all your meetings for that year and post that. However, if your schedule changes, the notice of the amended schedule is posted 3 days after the meeting in which the schedule change was approved. If you have an unexpected change, so for example, a change in venue, right? You had posted a Zoom meeting and now you decided you want to have it in person. You need 18 hours or more ahead of time, right? To post that, no less than 18 hours ahead to post that change. And if your body has an internet presence, they need to post it on their website if it's that 18-hour change. Now, I would recommend that if you have a website on your library website and you have a board page there, and on your main page you have like a link to board meetings or a calendar, I would definitely post all public notices of meetings on your website. Because the thing about the OMA is that you can't be too transparent, right? FOIA and the OMA, you can't be too transparent, and you want to err on the side of transparency. And also, it also acts as kind of a measure of good faith, right? So that if there ever is an issue and there's rumblings that your board is not behaving properly under the OMA, the fact that you consistently post things on your webpage, even when you don't have to, is actually a mark in your favor, right? It's a mark of goodwill. It shows that, hey, they may make mistakes, but they're not trying to hide things. Look, we post things on the website. We post our meetings minutes on the website. We post, so, it's always better to be more transparent than less transparent. And all of this is part of building trust with your community, right? And not just with your community, but with your staff. It's part of building trust between the director and the board, because the more transparency there is, the more trust there is always going to be. And when you're going for a millage, or when there does arise a controversy, it's always good to have that measure of trust between the community and between other stakeholders. It can make things a lot easier and a lot more comfortable. So when you talk about, let's talk about, the instances when you can have a non-public meeting of the board, right? So when that idea of a quorum does not necessarily mean a public meeting. So Section 10 says that this act does not apply to a meeting that is a social or chance gathering or a conference. So social or chance gathering. Social gathering. Well, usually, if you're in a library in Michigan, there's a lot of libraries. Actually, the majority of libraries are in pretty small towns where everyone knows each other. And, it's not uncommon for the same people to be volunteering for many things all over town or village or city. And so, it may be that y'all are at the same party or y'all are at the same graduation open house. And you just happen to all be there because you're friends. It has nothing to do with the library. Well, no problem. If you're all at a party, has nothing to do with the library, no problem. If you're at, a fundraiser for the library, no problem. If you're all at, a library function, like a program, right? Fine. The problem is, what you don't want is to discuss library business. So when y'all are together in a social or a chance gathering, no discussion of library business. That's really important. Y'all just happen to bump into each other at the mall or the grocery store. Same thing. Fine. It doesn't mean y'all can't be friends. Doesn't mean y'all can't talk and have fun. Do not talk about the library business. The big question has been educational sessions, right? Because this conferences. And if you look in the OMA handbook, it kind of expands that a little bit from an attorney general opinion. And it mentions the words kind of like educational or, and this is actually debated, and this is actually goes back and forth, and I've heard a couple different interpretations of this. There is an attorney general opinion from 1984 where they talk about educational sessions and workshops and working groups. And essentially what is said is that if you are a board and you are entertaining, say, like Rotary, or you're entertaining a particular like nonprofit group that wants to do a presentation or wants to discuss things with you, that's okay. If you all go to MLA, the Michigan Library Association conference, and you go to the same sessions, or you all go to, beginning workshop, or you all go to like the trustee trainings that, we do, then, those are organized trainings where there's other people from other libraries and other people who are interested in that topic there. That's fine. Where it gets sticky are things like I said, like retreats or private informational educational sessions. Those are things that you're going to want to talk to your attorney about. Different attorneys have different points of view on this. Essentially, if there's no discussion of library business, it likely is okay. The problem is proving that there's been no discussion of library business. And if you're having like even I go and speak to boards, right? And I've done it not in open session, but if I'm going to present to a board and it's just like this, where it's just a pure informational session, and I'm not there to mediate or counsel or anything like that, that's one thing. But if I'm there to talk about a specific problem the board is having with something, that gets very sticky if there's a quorum of the board there. And so that's where you have to be careful. And again, these lines are kind of gray. And that's when you want to talk to your attorney, because you also have to look at your environment and your community and your situation. And, you don't want to be in a situation where, again, it's not a problem till it's a problem, right? Because the penalties for breaking the OMA can be kind of stiff. So this is something, again, you want to tread carefully with. And a lot of it hinges on discussing library business. Let's talk about committees. So committees, right? You have a board, you have finance committee, you have personnel committee. If those committees do not contain quorums, right? So if it's just one or two board members and maybe a member of the staff or a member of the public, fine. Those do not have to be in public meeting unless the board as a whole has charged that committee with decision-making capabilities. So if you're a search committee looking for a new director and you are looking at resumes and you're making decisions to, toss resumes out, then that, again, that could be sticky, right? That could be decision-making. What your best bet is to review and discuss all of the different resumes and then send them all to the board and with your recommendations. Okay, here's all the applications we received. Here's are the ones that we recommend for interviewing. And then the board in open meeting discusses that. And so that's one example. So committees can be not in public meeting if they don't make decisions. If the committee is charged by the board with making a decision, okay, this committee is the building committee, and this committee is going to decide which architect we're going to use. It's going to decide on the preliminary plans. Then that committee has to meet in an open meeting, right? And again, your attorney can help you with some of these gray areas in determining what is the right action for your particular committees. You always want to err on the side of having a public meeting. If you're not sure, have a public meeting, right? Notice it. Maybe no one will come. In a lot of libraries I know, nobody comes. So you've done the right thing, and in the end, you have a meeting, with just the committee anyway. But it's always good to err on the side of a public meeting. Now, committees of the whole. If you as a board tend to have committees of the whole where, you have multiple committees meeting, all meeting together, then if there's a quorum of the board, you have to have that in public meeting, right? So even if the individual committees do not have to meet in public meeting, if you get all those committees together, and by doing so, the members of those various committees mean that there's a quorum of the board in the room, you have to have a public meeting. Minutes. Okay, so the law, section 1 of, now we're into 15.269, uses the word shall. So public bodies shall keep minutes, and it gives you a list of what has to be in the minutes. So date, time, place, members present, members absent, decisions made, and if you have a closed meeting, the purpose or purposes for the closed meeting. There has to be a list of roll call votes if any were taken at the meeting. So your minutes do not have to be extensive. They can be as extensive as the board wishes them to be, as long as they contain these elements, right? I can tell you from having to use minutes, historical minutes in different, like say, establishment research I've done, it helps to have as much detail in the minutes as possible, but there are also strategic reasons why you may not want to put everything in the minutes. So again, if you have questions about that, that's a good thing. Take a look at the OMA handbook. Take a look at some of the resources that I've put in the slides at the end. And if you're still confused, have a discussion with your attorney for your library, what might be the best strategy to take. Minutes are public record, right? And they're open to public inspection, right? And that's required by this act. Minutes are kept in perpetuity. So that means that if you look in the records retention for FOIA, board meetings at public libraries, the minutes for public library board meetings never get thrown away, right? They're kept forever. And how you keep them is up to the library, but the current version, the current minutes have to be available for public view. And the historical minutes have to be available too, but that's under FOIA. So the current minutes have to be available. Now, do you have to make them available online? Well, there's no requirement making them available online, but I can tell you again, if you look at good faith, if you put everything else on your website, or worse, if you've been putting your minutes on your website and all of a sudden you stop, that does not look good for the institution. It's always better to be more transparent than less. And if you're going to make your minutes, if you have to make your minutes available at your circ desk, you might as well put them online, right? And, people say, well, that might stir up trouble. Well, if there's trouble to be stirred up, then you have other problems than besides just your minutes. So, you're not going to solve anything by hiding your minutes, by putting them only at the circulation desk where people have to ask for them. So I strongly encourage boards to post their minutes online. Again, it can only make the library look good from a transparency standpoint and a public trust standpoint and a staff and director trust standpoint. So your proposed minutes have to be available within 8 business days of the meeting that generated them. And your approved minutes have to be available within 5 business days after they're approved. And so those are the timelines at which they would either have to be available at the circulation desk or reference desk or to the public in your building, or they'd have to be available electronically. So minutes, recap, they're required to be taken and made available. You have 8 days after for proposed and 5 days for approval. Remote meetings, right? And your hybrid meetings, the minutes are required to be on your website. So they're required to be on your website. If you're having remote meetings right now because of a emergency order, a local emergency order, then you have to post your minutes on your website. If you're having a hybrid meeting, I'd also strongly suggest that you put your minutes on the website. Okay, closed sessions. And I know this is tiny to cram it all in there. So there are 6 reasons and 6 reasons only for a closed session, right? So there's a lot of confusion about closed sessions. And I think there's a lot of misunderstandings among board members as to when they can have a closed session and when they can't. And sometimes I think it has to do with personal views on privacy. But remember, our personal views on privacy are not the same as what statutory views on privacy, especially when you're dealing with public entities and government entities. So the 6 reasons for closed session are to consider the dismissal, suspension, or disciplining, or to hear complaints or charges brought against, or to consider a periodic personnel evaluation of a public officer, employee, or staff member. So if you have a personnel issue, right? So you have your, a issue that has to be dealt with, a dismissal, a suspension against a staff member or the director. Or you have usually it's the director, right? Because usually the board doesn't deal with staff, right? So, and then, if you have allegations being made against a staff member, you have, or the director usually, you have personnel evaluations, right? Or determinations of raises. That's all, that can be done in closed session if, right? So if the person that the staff member or the director that is the center of this discussion requests it. So if for example, a library has an issue going on with their director, and so the board members want to discuss possibly suspending the director, the board members have to discuss that in open session unless the director requests a closed session. It's not up to the board whether a closed session is held on these issues. The only time the board may decide is if they have, say, an attorney opinion, or they're going to confer with their attorney on a telephone call. Then they can go into closed session because of attorney-client privilege. But if they are just going to be discussing it among themselves and discussing the issue, again, it's the person who is the subject of the inquiry or the subject of the evaluation that has to request going into closed session. I've had a lot of boards tell me, well, it's none of their business, or this is private. Well, it's not private. If you look at FOIA and you look at the kinds of things that are exempted from FOIA, it isn't these things. So personnel records, as far as evaluations go, are open records, right? So those are public records. So I could, FOIA evaluations of personnel. There's other things in a personnel record that are private, but this is not one of them. Strategy and negotiation sessions connected with the negotiation of a collective bargaining agreement, if either negotiating party requests a closed hearing. So union negotiations, if either the union or the library request a closed session. Again, only if that request occurs. Lease or purchase of real property. So if the library is considering buying some land or leasing the land from somebody, right, not to somebody, they can meet in closed session. And the theory behind that is if it was held in open session, right, then perhaps competitors who are also trying to get that piece of land could, find out what the library is willing to spend and then could undercut them, right? So in the interest of fairness for the library, excuse me, and to protect the library's interests, you can make that in closed session until a contract is signed. Once the contract is signed for sale or lease, then that information becomes public. As I said, to consult with their attorney, right? So if they have, an opinion letter from their attorney, or they have a call with their attorney and they're asking for advice, all of that can be in closed session because there is an attorney-client privilege issue. Now, this also mentions trial or settlement strategy. So that, again, would go along with attorney-client privilege. To review and consider contents of an application for employment or appointment to a public office if candidate requests. So if they are looking for a new director and they're going to be discussing different applicants. If they have an applicant that has requested confidentiality because maybe they haven't told their current supervisor that they're considering leaving, then the board could go into closed session to discuss that applicant's resume. But generally, unless individual applicants request confidentiality, then all of that is discussed in open session, including interviews. So interviews are all held in open session unless there could be some mitigating circumstances, but generally when you get to actual interviews, those have to be held in public session. So even if you have a committee that is looking at, applications, right? Remember what I said, if the committee is making decisions and they're tossing out applications, then they are making decisions and have to be in public session. If they're just reading every application and making piles of these are the ones we don't recommend, these are the ones we do recommend, and they're sending everything to the board to make final decisions on who to call for interviews, then that can be done closed session, or I'm sorry, in a non-public meeting. But the board has to hold interviews in public session. So even if a committee is charged with making decisions on who gets interviewed, again, in a public meeting, the actual interviews have to be held in a public meeting. And that is something that, sometimes surprises boards because they say, well, we discussed salary or doesn't matter. Salaries of public employees are public record. So a list of what library employees make, every library employee with their name is public record. Not their social security number, not their address, but if you have, the budget list and it says, either this position or this person makes this much money, totally open record, right? That's not something that is confidential. To consider exempt from discussion or disclosure by state or federal statute. So this really kind of is coverall that, there are different statutes that grant confidentiality or privacy or non-disclosure of certain topics, things like medical information, the obviously Library Privacy Act. So if there's a discussion about maybe a patron who wants to challenge a particular book that their kid took out, and there's a discussion of what the kid reads, that would be done in closed session. If there are, discussions with students. If you're a school public and you're discussing student behavior, that could be FERPA, which is the restriction on access to records of students. So there are many laws out there that do specifically restrict some kinds of information. And so when you bump into one of those, that would also constitute discussion in a closed session. But remember, as part of going into a closed session, you have to indicate why you're going into closed session. So that would have to be indicated. Again, employment discipline evaluations are not automatically in closed session. Closed session is, again, for information that is protected from other means. For example, another one would be if you have an employee that is suing you and you're going to settle with a certain amount of money. A lot of times those settlements, part of the settlement is that those details are sealed. And so that would be discussed in closed session. When you're going to have a closed session, you have to enter the closed session from a public meeting. So you can't just have a meeting for a closed session. You can't just have a closed session meeting. You have to notice a public meeting and then start the public meeting, go into closed session, and then come out of closed session, and then you'd adjourn the meeting, around other things you might be doing in that meeting. So you can't just, have a closed session by itself. So what kind of information is not protected? And some of this comes as a surprise, and this kind of also gets wrapped into, like I said, FOIA and open records. So staff salaries and employment contracts are not considered protected. They're public record. Staff benefits are public record, but certain information like medical information, social security information, staff personal information, addresses, family names, all birth dates, all that kind of stuff is protected. Employee evaluations, complete with the name of the employee, are not protected. Discussion of strategic plans. So if the board is having a discussion on how they want the library to move forward and how much money they want to spend and what they see as issues in the library, not protected. Contracts for purchases. So if the board is considering a large purchase, or the board, has an idea for something they want to do and they're not sure if the community is going to like it, doesn't matter. That's all public. Every bit of financial information in a library is public, especially the financial information. Financial information, the board is the steward of public funds. And as such, that information is completely open, right? So the budget, financial reports, financial information, audit reports, all of that stuff is open. So if the board is going to have copies of, say, a financial report at the meeting, and every board member is going to have one, or there's a discussion of a new budget or a new financial discussion or an audit, post that information on your website, because or make it available at the public meeting for people to view, because again, it shows good faith. Transparency is never a bad thing, and it will help build trust. And to be honest, your members of the public could request it anyway. Let's talk a minute about the 2020 amendments to the Open Meetings Act. So a lot of us have been discussing these a lot. Both of these amendments in 2020 added language that enables and regulates remote meetings. So right now, until December 31st, 2021, remote meetings are permitted only if there's a local state of emergency in the location where your body usually holds its meetings, right? And that's important. Where your body normally holds its meetings. It's not where the members live, it's where the body usually meets. So for most libraries, that's where the library is, right? Additional noticing is required, and there's some additional language that's required that are all listed in the statute at 15.263 subsection A. So that's worth noticing and noting and making sure that's being complied with. A lot of it, you have to put it on the website. If you have an agenda, you're not required to have an agenda under the OMA. But if you do have one and you're doing a remote meeting, you have to post that agenda on the website with the notice. Remote attendance of members of your board. I've been getting questions on this most recently. Right now, you have three options until December 31st, 2021. Now, remember, the Open Meetings Act is a statute. It does not have to do with MIOSHA rules. It does not have to do with the MDHHS rule. So these are a separate statute. The statute says that until December 31st, 2021, members of the board can attend remotely if the member lives in an area under a local state of emergency. So again, now we're not talking about where the library is, but we're talking about where that particular member lives. So if where the member lives, if that county or township or city has a local emergency order, that member can attend remotely, even if the area where the library is not under such an order and is having in-person meetings. If the member has a medical condition, and medical conditions are described as illness, injury, disability, or other health-related condition, there's no real detailed definition, right? It's pretty broad. There's no requirement for a member to discuss what their medical condition is, or, you know, they don't have to prove it. They just have to, you know, state that they are attending remotely because of a medical condition. If the member is on active military duty, so if you have a member that is, you know, on training exercises or cannot attend because of military duty, any one of these three options enables a member to attend remotely. Now, it's important to note that prior to these changes in 2020, the Open Meetings Act did not address remote meetings at all, right? And because of that, there was kind of this loophole that libraries could slide under in order to have members attend remotely. So if you had members that were in Florida for the winter, or you had members that went to their cottage for the summer and were not in town to attend meetings, they could attend remotely. Well, that no longer exists because the legislature has now addressed it. And the legislature has made it clear, both in the legislative history of this and in the language, that remote attendance is only permitted for these three options until December 2021. After December 31st, 2021, so as of January 1st, 2022, only for military duty can a member attend remotely. Now, the member still can get ADA accommodation if they have a disability that prevents them from coming to the meeting. Then they could be accommodated by remote attendance if they cannot physically make it to the meeting. However, you know, living in Florida for the winter does not constitute as a disability. So, you know, this is something that libraries are going to have to think about moving forward. There is some legislation in the proposed legislation that would amend this, because obviously libraries are not the only entities that are not happy with this. But there's a big reluctance in the legislature to permit remote meetings. So, you know, that has to be overcome. So if you are talking to your representatives, your state representatives, and you feel strongly about this, you might want to mention to them why meeting remotely is helpful to the library and is not harmful to participation of the public in the process, because that's what members of the legislature have stated are their concerns about remote meetings. Okay. So people say, well, but my board does this, or my board doesn't want to do this, or my board president thinks this. So here are some tips to get a reluctant board to comply with the OMA, or to make a board kind of understand that this is actually a thing. Or if you're a board member, to get other board members to understand. Varied and regular training for your board, right? So have your board get the OMA, you know, discussed and you know, refreshed often, and bring in different people to do it, because I'm a strong proponent that, I train a lot and I talk a lot and I present a lot. And I think people get tired of hearing the same things from the same voice all the time. And I think, I've had board members like wave their hands at me like, oh, but that's just that, lady at the state library that says that. Well, if I say it and then Ann Suring says it, and then you hear it on the, University of, or the MSU extension training, then, if you hear it from more than just one person, they hear the same thing, then they kind of might start to think, okay, you know what, maybe this is really a thing. So bring in different people to discuss this. Bring in someone from your municipality that has a good handle on this. It doesn't just have to be, me or, the regular same old people. Put in the bylaws that that a member has to undergo training, that new members are required to do a certain amount of training, or that members have to attend X number of trainings per year. Have their own policies require a certain amount of training, not just on OMA, but different things too. There's enough online training and sessions and even very brief things that they can view easily, that requiring a certain amount of training annually for board members is really not onerous. Give them reminders. If you hand every board member like a packet, or the trustee handbook or a binder, stick a cheat sheet in there. Here's a list of do's and don'ts for closed sessions. Here's the 6 reasons you can have a closed session. Put signage in the meeting room. Remember the OMA. Assign one, encourage the board to have one board officer's duties include being the know-it-all for OMA, right? So maybe the vice chair or the secretary are responsible for being the OMA brains in the board and responsible for saying, hey, we can't do that, it's against the OMA. Because sometimes board will listen more if their own peers tell them something. Post notices and minutes on the website. Make discussed documents available at the meeting, right? So I've had board members tell me that, oh, well, members of the public wanted agendas, but we just told them no. No, don't do that. That's not good. Have a few copies of the agenda if you're having an in-person meeting. It's not a big deal. The idea isn't to hide things, or the idea isn't to hope that the public don't find out about things because they're going to cause trouble. That's not the purpose of the OMA. The purpose of the OMA is the opposite. And if a trustee is really upholding their duty, then they have to uphold this. They have to really invest in this. Now, that's not to say that sometimes members of the public can't cause waves or can't create problems, but that's part of the process, right? And so when you sign up to work in public service, that's one of the things that you deal with. And again, there are mechanisms in place to deal with behavior. So, it doesn't mean that the board has to put up with everything, right? It means that the board has to be open and transparent with regards to its work. But that doesn't mean that the public just gets to do anything they want. So if you're in doubt, the FOIA and the Open Meetings Act are intended to provide transparency and citizen participation as part of a democracy that relies on citizen participation. Again, it's part of the process to ensure that citizens, when they vote for millages, when they vote for board members, that they are given the tools they need to make informed decisions. And also they have a right to understand how their money is being spent. If you're not sure and you need to make a split decision, err on the side of transparency. The only time that would be a problem is if you're dealing with information that is protected. And a lot of times that's information that most likely you'll know is protected. And if you have a concern about that, chat with your attorney to make sure before you release it. Okay. So you say, okay, my board's a mess And I have had directors call me and say, my board is having problems. They are totally disregard the Open Meetings Act. It's causing all kinds of issues. What can I do? Well, to report violations of the Open Meetings Act, you have a couple options. Generally, hopefully first, the individual, if it's one member mainly causing the problem, or maybe a faction of members causing a problem, bring in the board president, officers, or trustees. They can police each other, especially if their bylaws contain tools that let them do that, right? So if the bylaws contain their policies on behavior and ethics and duty requirements, and they also contain consequences for violation and enforcement mechanisms, then boards can police themselves. And very often there are people on a board who want to do that and may not have the mechanisms. So that's why it's important that a board have these mechanisms in their bylaws, and your attorney can help you draft them if you're not sure. You can remove a problem board member from a board office. So if it's the president of the board that's having the problem, or the vice president or the secretary that's causing the issues, they can be removed from their board office, not from their board seat, right? That's a whole other thing, but from their board office. And then they can be restricted from participating in certain committees, or they can be restricted from participating in certain projects. There may be a possibility that they're restricted from voting on certain matters, and that would be something you'd want to discuss with your attorney. You can talk to your library attorney if your board is having a big issue. Now, your library attorney, if you have an attorney that's specifically hired by the library, it's important to remember, if you're a director, that the attorney works for the board, right? Because the board is the legal entity of the library. The board is the legal representative of the library. So if the library hires an attorney, it's the board that is the client, right? So if a director goes to an attorney and says, look, I am seeing these problems, a lot of attorneys, it's in, it's in their interest to, if they have an opportunity to discuss this with their client and say, look, this may be an issue. If this is, are you having problems with this? And it's come to my attention that some of this is happening, or I read your board minutes and I noticed X. So, there may be some opportunity for some counseling there that their attorney could do to say, you guys are opening yourself up for some problems. If the situation is really bad and there's just, you've tried and there's no way, and the situation is really egregious, it is the local prosecutor who you would bring a complaint to in order to get, prosecution, or to get your board, legally censured. And then it would be up to the local prosecutor to bring charges or to institute a case or a litigation. You can also contact your municipal attorney. If you are a city library, a township library, a PA 164 library, and even if you have your own dedicated attorney, if you are really having problems with this issue, one of the things you could do is send a discreet note to your city, your municipality, to your municipal, your mayor or your township supervisor, to your, city council, to your board of supervisors, to your city or township attorney. Because at the end of the day, even if you're a relatively autonomous PA 164, your municipality still has some influence and some authority over the library. So there have been times in my experience that if the city attorney or the township attorney is notified, then a word goes from the township attorney to the township governing board, and then the township governing board discreetly contacts the library board and says, what the hell are you doing? And a lot of times that actually can shake a board into at least somewhat modifying their behavior. So if your back is against the wall and you're in a situation where you just have had it, this is one option you can employ. Now, there's negative sides to this option too. It depends on your relationship with your municipality and the local politics. But this is one thing that can be done. The legal penalty for violating of the OMA, if you're caught and prosecuted, is If it's intentional, it is possible to have a criminal a violation. Like you can have a criminal complaint against you and it's a misdemeanor. So it would be up to $1,000 per official and you're personally liable for this. So this means it comes out of the pocket of the individual official, not the library. Civil fines of $500 per official. So a prosecutor can institute a criminal case or a civil case. And if it's found that it's habitual and a board has done it more than once in this, or an official has been responsible more than once in their same term, it can go to $2,000 per official for subsequent offenses. So, you know, it can be pricey, right? And not only that, but it is a real reputation ding, right? If you have a you know, local newspaper, or you know, and the local newspaper blasts that the library board, you know, is being prosecuted for OMA violations, that's not pretty, right? And that can really, again, depending on your community, depending on the local politics, that can really affect your ability to operate and to get a, you know, a millage and all kinds of things. And that, you know, can create a whole lot of community hubbub and may not be a great thing. Okay, so here are some resources. I'm not going to go through them all. MSU Extension has a lot of good ones. I always love the Michigan Municipal League ones. Keep in mind that some of this stuff is not going to be specific to libraries, but I think a lot of you guys are used to that by now. The OMA handbook is really great, but it does not include the COVID amendments, so that's something to consider. And thank you. I appreciate your time. It looks like we have just a few minutes maybe to address a couple questions. Let me stop sharing. Okay, we're all back here. So let me go into chat here and see what we have in questions and see what we can look at right now. Let's see. Can you abstain from voting? You know, this is a question. One thing I didn't discuss in this particular presentation is Robert's rules. There are instances when people can abstain from voting. That's something that would be, you'd want to check in Robert's rules, or you'd want to hopefully the bylaws for the board would have some guidance on that. This is kind of a hard question to answer because there may be some more subtleties to this, but my understanding is that there can be some abstaining. The particular situation, you might need to run it by your attorney to double check, because I think there are some situations where you can, but there may be somewhere maybe it might not be real proper. I'd also, as I said, double check with Robert's rules if that's what your board has identified as their parliamentary guidance. How does the use of committees to explore different issues related to the library fall under the OMA? Okay. I had a board member come in late and miss some votes. I noted when she entered the meeting and she questioned me about that. I said it was to help explain why she didn't vote in previous votes. Was it correct to mention that she entered? Sure. Just like the minutes are not you're supposed to enter you know, if who's absent and who's there. I think that's perfectly legitimate to mention again why she's voting in some and not the other. I think that is perfectly reasonable. And again, you know, the OMA says that in your minutes you have to have the things that are listed, but that's not all you have to have, right? Your minutes can be more detailed than that. And I think that that example is an excellent suggestion of when you might want to do that. Can you have a board meeting with a quorum to discuss employee discipline or share something concerned about an employee seeking promotion? The only time that you can discuss employee discipline in closed session is if the employee requests it. Otherwise, it has to be discussed in open session with a quorum. And the same thing with an employee seeking promotion. If the employee requests it, you can. If not, you have to discuss it in open session. So there is not a provision to go into closed session for automatically for these two provisions. Depending on what the concern is for the employee, if it's something that could bring in the legal aspect, and you're going to confer with your attorney, then that conference could be in closed session. But you can't go into closed session because you have a concern. You could have a personnel committee discuss that concern first and maybe, you know, come up with their take on it that then could be, you know, discussed in open session if, you know, for that. How long do we need to keep the minutes online? If we started doing so, is there a time? Well, minutes have to be kept in perpetuity. So if the only way you keep minutes is electronically, then it's probably easiest to keep them forever if you're able to electronically online. If you're unable to, then you would need to talk with your attorney and your IT person for the best way to manage those and keep, you know, keep the most recent ones on your website. And then the other ones need to be put somewhere where the public can access them, because they have to be available for the public, or a way that, you know, they would send a you know, a request to the library, like a FOIA request, or and then the library would provide it. So there has to be a way to get to them. So that would be something that I would probably discuss with your IT folk, or potentially with your attorney for the best way to maintain those. You can take a look at the record retentions and the record, the you know, FOIA laws, the FOIA Act. But there are other laws that, you know, go into how, you know, keeping of electronic documents. And actually, let me make a note. I could put that law. I could add that to my presentation. There are requirements for keeping you know, public materials electronically. So I'll find that and put that in the information. But I would say for individual decision making as to, you know, when you're going to cut it off on your website, I would run it by your attorney just to make sure that you're doing the right thing. I would say at least the last year you'd want to keep on, you know, easily available if you're keeping it online. You are deciding upon a library director and receive 60 resumes. You have to deliberate these resumes in public. No, if you have, let's say you have if the board say designates a committee for the, you know, a search committee for this particular position, and that committee is, you know, given the job to weed through the resumes and come up with a recommendation. So the committee could go through all the resumes in, you know, not as long as it doesn't have a quorum on it, and then put them in piles and say, okay, here are the ones with our recommendations. And then the board could take their recommendations. And, you know, the board could take their recommendations and say, okay, we accept the recommendations, you know, of the committee. And then the board is making the decision to accept the recommendations of the committee. One way around this, you know, quandary of the applications is to use like a search, you know, like a headhunter or a company that helps you with locating a director, because then they can go all through this process for you. And since they're a private company, they're not subject to the OMA. And they don't have any board members on them. So they can go ahead and, you know, say, go through the resumes and toss out the ones that don't meet basic requirements, et cetera, et cetera. And even conduct, you know, preliminary discussions. But for sure, if you're not going to use one of those companies, then yeah, if you're going to just do the whole thing by the board with a quorum, then yeah, you'd have to go through them in public meeting. But if you're going to use like a committee that doesn't have a quorum of the board, they can do kind of the initial, you know, organization of applicants, and then the board could just say, drill down through the recommended applicants. If a library sends a proposed policy to board members by email, can board members reply to all in an email, and can the board president call each board member for the reactions and thoughts on the director's proposed policy? This is probably not a great idea. The whole purpose of public meeting is for the board to discuss this kind of stuff in public. So not a good idea. Definitely not reply all. And the board president calling each board member really kind of sounds like that round the horn decision making, trying to get around the OMA. They really should discuss the proposed policy in open session. That's really what should happen. Doesn't mean they can't get research. If individuals have concerns about, like, you could say, okay, we're sending out this proposed policy, we're going to discuss it in open meeting, in not the next meeting but the next one, so we're giving everybody a month to read this and to figure out their concerns and gather information on their concerns. So part of this the efficiency of this depends on each individual board member being prepared. And then when you get to open session to discuss it, the discussion shouldn't be too onerous, because everybody should be prepared to discuss it. There shouldn't be really any surprises. But discussing it one by one, that's really more like around the horn decision making. And I would double check with your attorney on that. I would not recommend that. In a situation where a committee has received some information, can they choose to decide how to disseminate that information to the whole board, give it out piecemeal over time, or must provide all information at the next full board meeting? This kind of may depend on what the committee is supposed to do and what their charge is. So if you're talking about like a search committee, and can they do resumes like each week they send resumes to the board, and then each individual board member reviews them and then they're discussed in a public meeting, they could do that. If they want to only formally turn a few in at the board meeting, they could do that. I mean, it really depends on what the charge of the board is, or that committee. Like, what is that committee supposed to do, and what authority did the board give that committee? So in theory, they could do that, but a lot of it depends on exactly what the situation is. They can't do anything that the intent is to bypass the OMA. But if the intent is to make things more manageable, then they could do that. If a library sends a proposed policy to board members by email, can board members, oh, we already talked about that. How do you handle minutes for closed session? So minutes of closed session, and thank you for mentioning this, I did not put that in there. Minutes of closed session can be taken in closed session, and then the minutes are given to only the board members, and then the minutes can be approved in closed session, but the closed session minutes are not kept with the general board minutes. So closed session minutes are kind of confidential only to the board. So those minutes, can be, disseminated to individual board members, but they're not maintained like the regular minutes are. Certificate proof. Oh, nope. We don't do certificates of proof of attendance here. If you need something, I'd be happy to personally send you an email, but we don't do certificates or attendance for the monthly webinars. But again, I'm happy to provide any kind of confirmation that you were here if you would like that. Okay, that's all of the questions. As always, I'm going to one more time display my contact information. Here's my contact information, my email, and my phone number. Here's the link to the survey, which you will also get in an email after this session. You probably will get it, since today is Friday before a holiday weekend. You'll probably get it around Tuesday, maybe today, we'll see. I have a couple other presentations. And if you would fill out that survey, we would love it. I personally would very much appreciate it. If you have ideas or interests in other legal issues that concern libraries that you would like me to present on, or guests you would like me to invite on, please let me know. I'm always looking for new ideas. I'm always looking for additional things that would be helpful to everybody. Okay, well, I very much appreciate everybody being here. Thank you so much for coming. I'm sorry it ran off just a couple of minutes late. And I look forward to hopefully seeing all of you in person at some point in the next couple of years. Take care, and I hope you all have a great holiday weekend. Thanks a lot.